Everyone's heard of copyright and trademarks and all of these sort of things, but very few people actually know what it means. But if you run a business or you ever take a photograph or you ever write anything, including messages, but particularly blog posts and letters and anything else, you're going to need to know what copyright and trademarks mean and how they affect you. But by the time you typically find out what they mean, it's too late because you're probably being sued, or you need to sue somebody else because they're using your video or your photographs or your writing or your trademarks or your brand logos or anything else. So in this video on art and media law with me and Alan Robertshaw, that really does rhyme, doesn't it, Al? We're going to talk about these things because I had an old friend of mine come to me just recently with a bit of a story. I'm not going to name names or organizations and things like that, but it's a very good example of where all these things come into play. Because essentially what we had is this, and I had my thoughts, and I'll come to Al, and you can give us your thoughts as well, which I know you'll agree with because we're on the same page here. So in this situation, this was an organization that had one of its members volunteer their services for free, which has been confirmed in their own writing, penned by way of messages on Facebook and things like that, to say that they were doing this for free. They were taking photographs for free, but they were named as the official photographer, name of the organization, photographer. And so all of these photographs were used on Facebook and memorabilia, events, marketing, and all of this sort of stuff. Only then, of course, later on, they fall out. Now, these sort of things, people eventually, if they fall out, that's when the problems come, because no one ever enters these things thinking that you're going to fall out, but people do. And it's when you fall out that then all of these things come up. So she then said, well, now you can take all of my photographs down because I've got the copyright. I never gave you copyright. You don't have the copyright. You don't owe them. You can't use them. And that's where the argument started. Now, hand over to you, Al. Where do they stand?
Well, yeah, I mean, first of all, what is copyright? Copyright exists in any work you create that involves some element of skill or judgment or talent, some element of creativity. And, there is another video on this channel all about the details of copyright. But just to give a little summary here, the copyright holder has the rights effectively to control the use of the work, when it's published, when it's reproduced, how it's used. And generally speaking, the copyright belongs to the person who created the work, or if it's a communal effort, they communally own it. However, in the case of photography, the copyright belongs to the person who commissioned the photograph. So, as we've said on the other channel, if, for instance, you go to a wedding photographer, you will say, I want you to take photographs of my wedding. Who owns the copyright then? Well, there'll be a contract, but effectively you will own certain rights in that yourself, not the photographer. So you can show your friends, you can reproduce them. Or what you'll probably find though is that the photographer will reserve some rights. If you want copies of these photographs, you have to buy them from me. I mean, this was back in the old days when it was physical negatives and producing actual paper photographs. It was a lot easier to control. Now they'll just give you all on a memory stick and say, here's your album. So it is a bit hard to control, but the law still covers it. There's always this issue of the law keeping up with technology, but generally speaking, the law is pretty straightforward. It's just how it's applied, and the mere fact that now it's easier to circumvent copyright doesn't mean it exists. So in this particular situation, what happened was this: say this was a photographer who'd gone out and just taken pictures themselves, entirely their own idea. I'm just going to take pictures of people. And generally speaking, in this country, you don't have a right in your own image. So, you can just take photographs of people. Then it'd be clear the photographer would own the copyright. However, when you're doing it in a sort of club situation, arguably, you're doing it with the permission of the club. They've all sat around and said, hey, you're a good photographer. Can you take some photographs? Is that a commission? And these ambiguities are sort of, what pay lawyers' mortgages. So in this particular situation, there's a really good argument that actually, no, the club or the organisation owns the copyrights because effectively they commissioned you to take the photographs. And we get into issues here about copyright, about contracts, because generally speaking, for there to be a contract, there has to be what we call consideration. In other words,
Hmm.
some value flow both ways. In exchange for me taking your photographs, you will give me some money. But consideration doesn't have to be money. It can be like a benefit in kind. And also, we have this saying: consideration must be sufficient, but need not be adequate. So, if if you're daft enough to sell me your castle for a penny or a peppercorn, then that's consideration, and that's why we literally have those peppercorn rents. They would just literally exchange a peppercorn to say something of value, even though
Hmm.
it's not really of value, has changed hands, and that stops it just being a gift, and therefore it makes it enforceable. So in this particular case, I think there's a very good argument that actually the organisation owns the copyright. How would the courts
Because
approach it?
yeah, because
Oh,
here,
sorry.
just to just jump in, because here, quite clearly, the organization has said, well, I'm guessing, but quite clearly they have said, anyone here willing to take the photographs as the official photographer or whatever, and said person or number of people have said, yeah, I'll do it, and they're doing it for free. There's no payment being exchanged here. They just assigned this title of official photographer. The person who, when in attendance, takes the photographs, and they get used for future marketing of events and all of that sort of stuff.
Well, yeah, and these are sorts of things the courts will look at, and the fact that effectively you've got club title photographer, the courts may well say, well, hang on a minute, you are taking these in your capacity as the club photographer, and that to me
Hmm.
implies that it's the club that owns the copyright. One thing you've got to remember with contracts is we have this thing called the intention of the parties. What did the parties intend the
Hmm.
agreement to be? Now, the rather weird thing in law is intention. It can be the last thing that you wanted, that either side wanted. You might have a situation where one party thinks, oh, well, this is what we intended to do. The other party said, no, no, this was the deal. And the court say, you're both wrong. This is actually what the deal was, whether you knew it or not. And
Yeah.
to establish intention, they will look at the circumstances in the round. They'll apply the starting position will be the law. Was this the photographer acting on their own, or was this a commission? And then they'll just, they'll literally look at the facts, and they'll look at things like how were the photographs used, how were they described, um, is there a copyright symbol up there? You don't have to use the little C copyright thing to establish a copyright. As soon
No,
as you
similar to
create it,
trademarks. We'll come back to that in a minute, but similar principle with trademarks. I mean, very, very brief tangent, but we'll come back to this in a minute. But you don't see registered trademark symbol, which you'll see if you look to the bottom left here. You'll see Black Barrister with a little R in a circle. That is a registered trademark. It really is a registered trademark. When you see TM, it'll be trademark, which is a trademark that is used. But again, you don't have to have either for it to be a trademark or a registered trademark. Same as copyright. You don't have to have it's a little C. You'll be familiar with a little C in a circle for copyright. But again,
well, of course,
you don't have to have it.
there are ways of actually registering trademarks, whereas there's not really a method of registering copyright, which is
No.
why to say about the app. That's why Proofify type apps are quite useful to establish copyright. In the old days, we would seal an envelope and post it to ourselves, or leave it with your bank or your solicitor to try and show
I
that
still have one.
you. Yes,
I've
exactly.
still got one. It's got to be 30 years old now. It's still in a sealed envelope from about 30 years ago.
I have like on a shelf in another room. I have like certain things that one day we might have to open that in front of a judge, and I'm just dreading that
Yeah.
we open it. Ta-da! Oh, hang on, it's empty. I'm sure. I'm
That's
sure.
the
I'm
wrong
sure
one.
there's something
Damn it.
That's what I
Yeah.
thought. That was a bit disappointing. It's like,
Yeah.
ta-da, world's worst magic trick.
Yeah.
Yeah, because you can register trademarks, and you register them in different jurisdictions, and registering trademarks does give you extra protection. Although it's not necessarily
It's
definitive.
not a slam dunk. No.
No, but with copyright, you basically establish it by just the way you utilize the work. The other problem they might have here is there are certain defenses to any sort of claim, and one of them is what we call acquiescence. And it's effectively, well, you've put up this with so long and not objected till now that basically, even if you did have any rights, you've effectively been deemed to waive them. So that's always a problem. So if you are somebody who takes photographs, I mean, in terms of this, you always get these photographers, and anybody, if any photographers viewing this will know about hey, do you want to take some photographs of my event? You'll get the exposure. Well, exposure doesn't pay your rent. Unfortunately, exposure can count as consideration because, it can have a
It's
value
valuable,
if
yeah.
if you go out there and your photograph, people are going, wow, this event is something I want to see pictures of, and that exposes your brand or yourself to the world. That does have a value. I mean, like I say, it doesn't feed you, but the problem with that is you say, well, hang on a minute, I've never got paid for this. Oh no, but you got the exposure. for
That's why
exposure
I'm
is a
so
popular
keen
thing.
to clarify whether when I mention a brand on my main channel, because I get anything between 3 and 5 million views a month. When I mention any brand on there, I will say not a sponsored video because, well, for one, I don't want people just assuming that it's sponsored, which if it isn't, I do have partners from time to time, and I make that clear. But at the same time, for that reason, I make clear that if I mention any brand that is not sponsored, because I
Well,
don't
also,
want that association.
there's EU law about this. Now, obviously,
Mm.
we're not in the EU, in case you haven't noticed.
Hmm.
Funnily enough, yesterday I attended a very, very interesting thing with somebody called Chiara, Italian, like law student. Well, I say law student. She's doing like a PhD thesis on this, and it was all about the use of effectively product placement in social media. And there are very strict rules about this actually, and it's funny because you can put any sort of product placement in a Hollywood blockbuster,
Mm.
but when it comes to things like social media and YouTube, you're supposed to actually say this is sponsored content,
Yeah.
because and indeed we've had an interesting thing. There was that collapse of that crypto exchange, FTC or whatever it's called,
Yes.
and now people are suing the celebrities who endorsed
Endorsed it.
that
Yeah.
product by saying, well, hang on a minute, we relied on you endorsing this. And that's why we invested because we trusted you. The defence, of course, being, hang on a minute, you can't sue somebody who does a car advert just because the car's rubbish. They're just they're just reading from a script. But
Yeah.
it's going to be a very interesting one because the trouble with social media, because it's more interactive, it's hey, this is great, and I personally use this. Now, when you see an actor on television, you don't really think that they're necessarily buying that brand of bread, or they have a pension with that company, or they drive.
Usually not. Yeah.
Usually not. No, but when it comes to social media, is it going beyond that? Are you actually
Mm.
endorsing the product? And this is why it all becomes very, again, it's how the law tries to keep up with new technology. But
Hmm.
there are lots of EU laws about this, precisely to protect people from, and especially where you've got audiences, for younger people, because it's a little bit of the Wild West on social media,
Oh,
and
yeah.
a lot of people falling for these things are perhaps people who might not have capacity to enter a contract. There might be
Hmm.
minors in their respective jurisdictions, but it's a relatively unregulated marketplace. It's meant to be
And
regulated.
yeah, and there's some that can come close to advice as well, which um, if you're talking about financial products or anything like that, you've got to be very careful. I mean, have been uh, qualified with finance qualifications many years ago before coming to the bar and everything else. But I've been in business for lots of different things. But whenever I mention anything to do with money, I clarify not financial advice and it's not legal advice every time for that reason. And even
Well,
when
I'm Brett, so don't listen to me about anything financial. Also, I would like to get my disclaimer out now that the words expert, legal, and advice may not conform with usual dictionary definitions. So just in case you're listening to me on it.
yeah. But there we go. No, it's but yeah, the trade. We coming back on topics. Trademarks we talk about. So there's again, you have to be careful when you're mentioning trademarks and how you mention trademarks and what you're saying about them and things like that. Again, but usual defenses for saying
And
something wrong will
trademarks
be if
are
it's
very different
opinions
from
and
copyright. That's
very
something
different.
people conflate trademarks and copyright. I mean,
Mm.
the classic example is Banksy. Banksy is famous for saying copyright is for losers, so he doesn't copyright his work. However, somebody used one of his images as a trademark. And the thing with the trademark is you don't need any sort of creativity in there. You can use anything you want. I mean, the classic example is the red triangle, for Bass beers is supposedly the oldest trademark in the UK. But trademarks have been around forever. Roman bakers used to trademark bread because bread was a very big food staple in Rome, and the quality varied a lot. So the good bakers would put their mark on their loaves, and people would rip off their trademark, and there were quite severe penalties for doing it. The consumer laws. The funny thing about consumer laws is um, they've always been really strong throughout history. I mean, you're probably familiar
Yeah.
with the origin of the phrase "baker's dozen," meaning 13, because if you sold underweight bread, it's like I want to buy a dozen loaves, and they're all of half-pound loaves each, and you're slightly under. The penalties were really, really severe. So people would go, "I'm not going to risk this. Have an extra free
Have
loaf,"
an extra one.
and that's
Yeah.
literally where we get baker's dozen from. But with the Banksy case, somebody was using one of his drawings as a trademark. And he tried to, well, his company, Paintings on Walls, which obviously, if if you want to know who Banksy is, just look at who owns the shares in that. But basically, they tried to bring a claim for trademark infringement. And the trouble is, there were two things. First of all, they said, well, you just said copyright is for losers, and trademarks are a form of IP, and you've shown you don't like IP. But more importantly, you have to establish that you have an interest in that trademark yourself. And it has to be you've got to have legitimately used that trademark. And the problem was they had set up a store using that trademark themselves to try and, say, well, we've actually already using that trademark. But they set up a store that was open for 1 hour. And they actually, unfortunately, publicly said, we're only doing this to protect the trademark. It's not a real shop.
Yeah.
Now, hats off to Banksy's legal team for being completely honest about this and just going, there are certain things that you might not want to mention because, as we always say, always send it, every email or tweet or anything you ever say or write, always imagine that one day a judge will be reading that
A
out.
judge is reading, indeed. And many an email written not for the person that it's been sent to. But it really is a use it or lose it situation. I mean, just because you got it registered doesn't mean that's it. It's yours forever. You need to use it. And there's all sorts of implications. But yeah, so there are overlaps between copyright and trademark and everything else. But the copyright is always an interesting one. I've had a number of clients in the last few months or so. Again, bog standard, typical, virtually every time it happens type of event. And it's usually wedding photographers because for some reason they tend to get the raw end of it sometimes. So they're told to turn up and take photographs, so they turn up and take photographs, or it's for an event or whatever. And then they either find that their photographs are being used without their permission, being copied without their permission, reused and all that, or modified and that sort of stuff. But if you, as Al said, if you turn up and there's no other arrangement in place, they're probably yours. But if you're doing it under the instruction and request of someone else as a commission, or even in this case, if it's done for free, but as the official sort of in-house photographer, even for free, it's still akin to employment. And if you're doing it in the course of employment, then it's your employer, again, that's going to own them and not you. And then if it's a contract, it depends what the contract provides. So you have to read the contract carefully.
Yeah, you see a lot of employment contracts that say if you come up with anything that attracts IP protection while working for us, not necessarily even while on the job, we own the copyright. Anybody working in IT will have noticed this in their contract, or should have done, that if they come out with a fantastic piece of code, you've got to be really careful. Let's say your job is like data entry, but at weekends or in evenings you produce the next killer app. Be very, very careful that
what the contract says
belonging to your employer. I mean, that does happen a lot. And you've also got to be very careful as to, if you've come up with a brilliant idea, do you wait till your employment contract comes to an end or resign and then do it? But then you get people going, well, hang on a minute, you didn't come up with this just overnight. You were obviously thinking about that when you're working for us, so it belongs to us.
This actually happened with us many years ago. We were employing someone who is just as an administrative assistant, but whilst on the job, literally in the office, was developing an app for, I think it was something to do with selling houses or whatever it was, some kind of new agency type software. So we sat down and had a chat and said, you realize that whatever you've produced, we own for that,
Yeah.
exactly that reason. I said, so, we can have a sensible chat about what you really want to do. Or, great, give us all the code for the software because we might like to develop it further. Anyway, he left, but
Well,
exactly
this
that
comes
situation.
into this comes into there's a classic thing is when is a work of art finished? And there's that old saying that a true work of art is never finished; it's only
Mm,
abandoned. But it's a very common deal is for people to sponsor aspiring up and coming artists. I will give you like an allowance, but in exchange, everything you create in the period I'm effectively funding you, I have a share in, or I either belongs to me, the
mm.
art, the artwork or the IP or something like that. And then you get people going, I'll do my 2 years, but I'll leave with a complete set of unfinished paintings, and I'll finish them. When I actually, when I'm no longer in your employment, and therefore none of them belong to you. Now, interestingly, in France, that's the one jurisdiction where it's actually in the law that it's always up to the artist when the work of art is finished. In other jurisdictions, it's a matter of
Degrees.
facts. Every case tells its own facts because it's like it's not finished, and then I no longer work
One
for
line.
you.
Yeah.
One line, now it's finished. Thank you. I can
Yeah.
sell it myself. I mean, what you
Yeah.
quite often find, you find this with a lot with what we call consignment, where people put art in a gallery on sale, and
Mm.
any sale during the period it's in the gallery, the gallery gets commission. But there'll also be a run-on period for like 3 months or 6 months,
Which
saying,
makes
and
sense
any
because
sales
if,
after that.
yeah, that makes sense because if someone's seen it and you never buy art on a whim, um, I don't know,
Don't you? All right. That's news. That's news to me. I nearly spent 400 quid on a paper yesterday. Luckily,
well,
something broke.
okay, it depends what you were looking at. I was looking at one some years ago. It was in the region of £8,000 or £9,000. We didn't buy it in the end, but I would hope that most people don't buy that on a whim. But we didn't buy it in the end. It was a very interesting reason why we didn't buy it in the end because part of I'm not going to name the artist to for any detriment, but there was something about it which was linked to the spirit world. I'm not going to say any more than that, so that doesn't really give away who it is. But with our beliefs from a Buddhist background, it didn't quite equate with our views, so we didn't. It just didn't sit right, so we didn't go with it. And it was the only one really out of the whole lot that we looked at that would have been of any real interest. But no, I
It's
would
funny you say
have.
that. Look, there's two things arising. First of all, when it comes to knowing who an artist is, don't look up who Banksy is. We all know who Banksy is, but I quite like it. I like the magic. It's like not knowing who the Sting was. We all knew who the Sting was, but it's more fun not knowing. So
Yeah,
please don't ruin it. Also,
yeah.
in terms of Buddhism, I was in a Buddhist temple, well, nunnery, very recently, and the one thing there is they said don't take photographs inside. Take any
Mm,
photographs you want in the grounds, which is lovely. It's all very lovely architecture and nice ponds. But I understand why inside this wasn't a copyright thing. This was a look. This is a very serene space. But I have the visuals in my head, and it was absolutely stunning because you got the huge Buddha
mm.
statues, and somebody was explaining to me about all the different iterations of the Buddha, um, and what all the different statues meant, and and all just the different cultural things. It's like, oh well, you notice like how that statue is holding their hands. Well, that means they're from this tradition and they're from this background and this ethnic group, and because of this slightly different Buddha. And that was absolutely fascinating. But that's interesting because had I have taken the photograph, apart from the fact it's very, very rude,
Mm.
would they have any comeback? But what you'll notice is because let's say you want to take some photographs of something that's copyrighted. Um, you can do that in a public space. If it's a permanent exhibition, like a statue in the park, you can take a
Mm.
photograph of it. If it's in a museum, though, even if the painting or the statue is out of copyright because it's an old one,
Mm.
what you'll probably find is that the museum or the gallery they'll say, we prohibit any photography in here. And if you do take any photographs, we own the IP.
Yeah.
That's their. Oh, oh sorry, he's still there. Sorry about that.
Yeah.
That was our good friend AB. So
Indeed.
I was going to think I'm ignoring them, not ignoring them. So I must actually. So if they call you afterwards, don't say Alan was being rude. But yeah, if
No.
you'll find that with you know, if you go into sort of like galleries and things, that's how they protect it. People do that with the military. If you sign up to the military, what they said is because of freedom of expression, they can't necessarily stop you producing a book of your memoirs. We had,
Mhm.
the SAS had this where some of the guys are producing books, and they said, "Well, you can't do
Yeah.
that." So, well, we've got freedom of expression. The courts there said, actually, no, you haven't, because it's a privilege joining the SAS. Nobody forces you to do it, so you've agreed to waive your
Mhm.
normal, free speech rights. And then they all went, well, hang on, Peter de Villiers wrote a book. But what they do now is they will put a thing saying, well, you can write it, but we get the royalties. So, and that happens. That's quite a common way of doing things, where we can't prohibit you from writing or speaking about this, but what we can say is, well, we own the IP rights in that, and that's a backdoor way of, if you just want to get it off your chest and speak, well, they can't stop you doing it, but they can stop you profiting on it.
Interesting. Well, there we go. So, like I said at the outset, anyone that's ever taken a photograph, ever written anything to anybody on a blog or whatever, composed music, or run a business, you'll be coming across all of this at some point. And we've, even in, what are we now, 25 minutes, have barely scratched the surface
Sure.
of what there is to think about in these areas. And I find them fascinating because we, as a business, we've come across them all over the place. Just the examples that have come up in this chat literally had somebody working for us developing something that technically, according to the contract, we would own if it was any good. We've had people write blog articles for the website and then want to use them themselves, and then said, we want you to take them all down. We don't want you to use them anymore. Well, you wrote them for our website, so it doesn't work like that. But it's
I had somebody wanted to reproduce something I'd written that had been used on a website, and they said, "Oh, can we use this?" I said, "I'm not sure." I said, "I don't know if it's up to me." And we were sort of trying to argue. Okay, well, who owns the IP in it? And the irony is, it
yeah.
was an article about IP law. Going like, you can tell how great an IP lawyer you are that you don't actually know whether you own the copyright in something you
Yeah.
yourself wrote.
Yeah. Here's everything to do with IP and copyright law,
It was,
except whether I own the IP and copyright. Yeah. Interesting. But there it is. But don't forget, we are on Art and Media Law with Alan Robertshaw, so it rhymes, and you must subscribe, because this channel growing nicely and quickly, but we want it to grow even more quickly. So please do hit that like button and subscribe,
please
and the bell
comment.
notification, so you get notifications of the new videos when they come out, so you can come back and watch them all. And with that, unless you've got any closing thoughts, I think that's a nice sort of rounded discussion.
Please, like, I love reading your comments, and also your comments give me ideas as to future videos. So I very much appreciate, I always say this is a Socratic thing. I'm not just here, I've just been teaching some more bar students, and I always say, look, it's a dialogue, it's not a lecture. It's meant
Yeah.
to be a two-way thing, this. So please feel free to interact and ask further questions and make suggestions as to other things you'd like to hear about. Because the whole point of this channel is, yes, I'll be nerding out on all sorts of things, like the Whistler video and stuff. But at the same time, the purpose of this is to be useful to people. At the risk of putting lawyers out of a job in the future, we want this to actually be of some use to people. So if there's anything you want to hear about, just let us know.
Well, that's the other thing. I mean, we'll close with this, but that's the other really interesting thing is I feel that I've done a really good job for a client if they don't need me anymore. And so it really is what we're here for. And so when it came to this channel and my channel created in lockdown, I thought, well, I can't sit still for more than 5 minutes anyway. And so in lockdown, I thought, well, I've got a bit more time on my hands. It's not quite the same now. I do struggle to get the time, but I get the time one way or another. But yeah, it was about making it available to as many people and making it as simple as possible and to ease these problems as much as possible for as many people. So I echo that. Yeah, leave the comments, leave the requests, and we'll come back to them. And with that, we'll thank you for watching. Make sure you subscribe, and we'll see you next time.
Namaste.